Hello, everybody, and welcome back to Mediation Monday. I'm Alan Crone, CEO of the Crone Law Firm, and this is a video series with Dr. Jim Latta and I are putting together on mediation and the mediation services offered by the mediation section of the Crone Law Firm. Jim is one of our affiliated mediators and works with us in our mediation practice. And Jim, again, thank you very much for your time in putting this video series together.
My pleasure, Andy.
Very good. Well, we've talked in general terms in the last two segments about kind of who we are and mediation in general. And in this particular installment, we want to talk about how the nuts and bolts of how a particular mediation might work and what the roles of the various participants in the mediation are, because everybody has a specific role to play within the mediation process. We've talked about how mediation is a process, and in any process, you have different actors have different roles to play within that process for it to work and come together. Let's do a little bit of recap, if you will, Jim, about the kind of the characteristics of mediation. And if you would kind of talk a little bit about the overall role that confidentiality and facilitation play in a mediation.
Well, Alan, one of the beauties of mediation is that it is a confidential process. By that is meant that what is said in the mediation remains there. A court cannot subpoena material from it, cannot request a transcript of it. The mediator cannot be subpoenaed to court to testify or be part of a litigation of any kind. All that is reported out to the court publicly, because court proceedings are basically, unless sealed, are public, is simply the result of the mediation, whether it was successful, and if so, what are the agreement terms of it, and if it was unsuccessful, it was unsuccessful. That's basically what the court hears, okay? So the beauty of that, like counseling as a counselor in my world, is confidentiality. I cannot imagine counseling to be successful as a profession and as a process too, without confidentiality. People need the safety of confidentiality to open up and to explore options, explore new ways of thinking, new ways of reacting, new ways of proposing a solution, a workaround to a conflict, which we've talked about as an impasse. An impasse means two people are locked down in some type of struggle and they can't get around it, okay? They can't get around it. So it's critical, the role of confidentiality, and also critical that the neutral have relationship with the participants in which there is trust. Same thing in the counseling world. If your patient you're treating or person you're counseling doesn't trust you, the therapist has no leverage. In the mediation, the mediator, called the neutral, which means they're not a judge, they don't make declaratory judgments about anything. They don't practice law. For example, I'm a therapist, I'm not an attorney. But as a therapist, I bring to it, I believe, a great deal of experience, 40 years of experience with human interaction and human process. And that is invaluable in a mediation because that's what a mediation is. Mediation is not so much about the law. It's not really about the law in that respect. It's about how people, participants, can, in a process that is outlined and facilitated and is safe and is free to explore options for solutions to impasse that they've never had before. And it also, if I may say, facilitated by communication. So the neutral's major role, in my view, in avoiding impasse and shutdown to resolving conflict is to facilitate communication. Therefore, how does it work? Basically, the traditional model is two-room mediation. The step one of a mediation could be a referral from a court, or it could be a call from an attorney whose clients want to mediate or want to propose that, or even an individual could call the Crone Law Firm and say, we want to try to mediate something. An individual, I've dealt with all those, okay? So it can come a number of different ways. Mediation is flexible, very flexible. But clearly, if it is indeed referred by a court, then that usually means there are attorneys involved. So the role of the court is for the referral. The role of the attorney of the clients involved is to be in mediation, a resource for the participants. Mediation is not an exercise between the lawyers. That's called litigation, and that's in a courtroom. In a mediation, the attorneys can be present if the clients want, in individual rooms for confidentiality purposes for everybody, and the attorneys can advise the clients as the clients wish. But mediation is the work of the participants. That's what makes it beautiful, workable, and long-lasting.
All right, let's talk a little bit about the nuts and bolts of it. As you say, there are probably as many different ways to conduct a mediation as there are mediators and as there are cases. The traditional, typical way, at least in this area, to do a mediation, as you say, is to do what they call shuttle diplomacy. But typically what will happen is the parties will start out in one room, perhaps one big conference room.
Correct.
And the mediator will lay out certain ground rules. The mediator's rules require that the mediator give everybody kind of a background of who they are and how they work. And so that's usually done in a joint setting with the parties sitting on in the same room on opposite sides of a table. I always, as a mediator and as a lawyer, I always ask that the parties sit closest to me, the mediator. And if I'm a lawyer, I will defer that head chair, if you will. If you picture a conference table with the mediator sitting at the head of the conference table and the litigants and lawyers arrayed on opposite sides, I always want the parties in that chair closest to me as a mediator. And as a lawyer, I want my client to be between me and the mediator. And the reason for that is I want to set the tone very early, that this is not, as you say, is not about the lawyers posturing or arguing their case. There's a time and a place for that, but that really it's the parties that are in control of the situation. And so as a mediator, I don't want there to be anything literally between me and the parties. And as a lawyer, I don't want to be in between the mediator and the party, my client. I want the mediator talking directly to my client and only engaging me if necessary. And sometimes my client, as a lawyer, my client will say, look, I want you to do the talking. And I'll say, fine, but there's sometimes when you may need to do the talking.
That's right. And a really good mediator respects that dynamic between the attorney and the client in the mediation. And like you say, usually that's step one, a single room introduction, okay? And that's very important to set the stage. And what you're talking about by seating is really important, because if you want to look at seating, that's a form of body language. And that communicates to everyone in the room to reinforce what mediation is, okay? That is very important, and very important for the neutral, the mediator, to encourage and reinforce that this is the parties' mediation. They are the ones who make the agreement, and they're the ones who sign it, and they're the ones who live with it. So that's a very important thing. The next step is typically to be, and I do this in individual rooms, basically, Alan, a statement of what are the problems, what are the issues at hand. In the freedom of individual confidential rooms, let each party, to the mediation, speak their mind about what the issues are. They want to be heard, they need to be heard. So typically that's a step two, and that begins a two-room process that you're talking about, okay? Which is traditional, actually, okay? And then in that way, there's information that is gathered. Usually the attorneys provide a pre-mediation statement of the case. They're asked to provide that, attorneys for each client. They send that to the mediator, okay? So I will have read their pre-mediation statement, the attorney's representation of what the conflicts are, okay? And that's very important to know. Then, so the conflicts are described and identified in the individual rooms, and based upon that, then, there can be clarification conversations between the mediator even and each individual participant in the mediation. What are the conflicts? How do you see the conflicts? And that enables a mediator to get to the point of getting to the deeper issues of what is your investment in the conflicts? Why are they conflictual for you? Okay. And what emotional part of you is invested in perpetuating that conflict? Okay. So I think that's critical conversation and trust building between the mediator and each participant in the room, where safely they can express themselves fully, including their own doubts, their own fears, their own lack of understanding, their own anger, their own whatever they need to express, okay? And like you say, their attorneys can be present for resourcing, for legal support questions. There can be complicated mediations in which you want their attorneys there who are very expert in the law about certain things if the client has questions. But the neutral doesn't practice law, can't answer those questions, and shouldn't, okay? Then usually you get on after clarification. One of the big processes there is to identify what is the problem to be settled. That may seem simple, but it's not so simple. There may be many elements to the problem that need to be settled and identified and agreed upon that is the problem to be settled, okay? That I have in this particular issue, now if I'm participating in the mediation. And then most importantly, step 5 usually is working with the participants. And again, the mediators moving back and forth between the rooms, listening back and forth and injecting the best of ideas and solution-focused comments to each side, gauging what their positions are, what their emotional positions are, and where are they most workable, where are they most open to reframing, put in a different context, what their emotional investment is, okay? That is generating options for solutions back and forth, okay? The mediator is critically important to that process because that is where impasse is overcome, right there, in that process itself. And my experience of mediation, that takes the bulk of the energy and the time as you would expect in a mediation, okay? So impasse resolution, step 5, let us call it that, is the mediator playing that critical mediator role to encourage consideration of options on both sides. And the mediator can inject ideas for each party to consider, not solutions, not judgments. They're not legally binding. They are conversational suggestions, much like in therapy. Have you thought about this? Have you thought about that? Okay. And in my experience, this may be an idea. That may be an idea. You can't prescribe a solution for this process. Okay. And then lastly, step 6 typically is the finalization of an agreement and outcome of mediation.
Which hopefully you get to in 100% of the cases, but not in all cases, obviously. But that's the ultimate goal, is to.
That's the ultimate goal. And I tell you what, I have read some of the studies that have been done indicate, not always, but up to close to almost a majority of mediation cases settle upward to 70-75% depending on their nature. You know, they can be very complex. Mediation is very flexible. It can handle very complex issues, which is really great, okay? Or can handle simple issues. You're not both been involved in situations of disputes where what is being disputed, as Chief Justice Warren Burger wrote beautifully years ago about mediation as a new process to help resolve issues that litigation cannot manage. Okay, sometimes the greatest battles are over the least amount of reward. And he said in his quote, which is a wonderful quote, many times litigants will pay much more than the value of the item being disputed over just to dispute, okay? So you and I both seen cases where it is disproportionate, the energy, time, money, sweat, blood, and tears invested in a conflict over the issue of conflict itself. So you dig into that and find out that is not really the issue. That's not really the issue. The issue is something deeper, unresolved from the past, whatever that may be. And that comes out. I've always believed myself that attorneys, and the ones I've known and worked with, are counselors at law. And I stress the word counselor because I've seen them at work and I've worked with them over the years in an interdisciplinary way to counsel people to think through what is really going on and clarify what their emotional drivers are, what is pushing this forward. And I think that plays out in mediation clearly and plays to the strengths of mediation has.
Yeah, and I think in terms of the role of the lawyer, to amplify on that, at a mediation, is to be a counselor and not an advocate, and to help advise and support the person make a decision, advise them on what the law is, advise them on what their experience of the likely outcome is going to be, but not to rattle sabers and try to intimidate the other side with the strength of the case, because if that were a determinative factor, we would need mediation.
And I think it's been discovered in mediation as a profession that non-mediators can bring a strength to that process, Alan. Not the law. I'm not a lawyer, but this is not about the law. It's about people and who they are and who they wish to be, and their own dignity and their own sense of purpose and their own sense of what is just. And I like that.
Yeah, and I think what a lot of people lose sight of is that in mediation, you can often get an outcome that you could not get at trial. And not what sometimes it's a non-economic outcome.
Outcomes.
But that's the beauty of it. And the last thing that I think we should say is that frequently cases will settle in mediation, but not the day of the first day of mediation. You may have a mediation that goes all day. You reach a certain level of impasse. The mediation is adjourned, or maybe it's concluded, and then a week later, a month later, however long it may be, those negotiations resume, and you building on the foundation that you laid in that first mediation session, maybe with the help of the same mediator, you're able to resolve it. So you never say never, and at some point, hopefully, you can get to that point of resolution. Well, it looks like we're out of time.
Okay.
I could. This is a conversation we'll pick up again next week on Mediation Monday, when we'll talk about kind of why it works. What are the elements of a mediation that propel it forward to resolution? Again, thank you, Jim, for your time. I appreciate your help and thoughts on this, and I appreciate all of our listeners and watchers, our viewers. That watch Mediation Monday every Monday when it comes out. Again, this is Alan Crone, CEO of the Crone Law Firm. Thank you for watching, and I look forward to seeing you next week. Thanks a lot.